This video contains excerpts from an online workshop that the U.S. Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by U.S. Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
So today we want to talk about what it means to have live witnesses testify. We want to talk about, is it worthwhile going to the trouble and cost of having witnesses come to court and testify? And I think probably instinctively we all have a sense that seeing and hearing witnesses testify in person has some value, but it's difficult to have a really deep understanding of that without having the experience of sitting in many, many trials, watching many, many witnesses, comparing the impressions that witnesses make when they testify in person versus the impressions they may make through their written statements or even written testimony. So we can't give everyone that experience, but we're going to try and do the next best thing and ask three people who have had decades of experience dealing with witnesses, calling witnesses, examining witnesses at trial, hearing witnesses testify, and trying to determine whether witnesses are telling the truth. And we're going to ask them to share their experiences with you.
I was a prosecutor in the Manhattan DA's office for 5 years and the first assistant at the New York State Organized Crime Task Force for 9. But I've been a judge for 30 years and have presided over more than 400 felony criminal cases. I would guess in maybe 50 or 70 of those cases, they were bench trials where there was no jury. I was the finder of fact. But in the rest, they were jury trials, and the jury ultimately made the decision. But I've also presided over suppression hearings, and in those I was the finder of fact. So I've been called on to make credibility determinations in many, many, many cases.
I graduated from law school 40 years ago, almost to the date. I spent 15 years as a practitioner, including 5 years as a federal prosecutor trying criminal cases for the government in federal court. And for the last 27 years, I've been a United States Magistrate Judge, 9 of which I spent as the Chief United States Magistrate Judge of our court. Like Judge Marcus, I've presided over fact-finding by the bench myself, as well as jury trials, but my experience as a judge has been more on the civil side, but not exclusively on the civil side.
I am a practicing lawyer and always have been. I've practiced law for about the same amount of time as Judge Gold, about 40 years. I've done this on the criminal side, from both sides of the table. I was a prosecutor for many years, a federal prosecutor here in New York. Then for the last about almost 30 years now, I've been a defense lawyer. So I've tried over 25 cases. I on both sides, a mix of both sides of that. So I'm very familiar with the trial process, the credibility finding process, the preparation of witnesses, the cross-examination of witnesses. This is something that I love. I love to do it. I love to study it. And thankfully, I've been able to do quite a few fairly high-profile criminal cases on the defense side. And I've enjoyed that and learned a lot about witness credibility in the course of that career.
Now we're going to show a brief excerpt from a well-known movie in order to illustrate how a witness's live in-court testimony can provide information that could not be captured by a written statement.
I would like to...
I have not quite finished.
You are registered, are you not, under the National Health Insurance Act?
Aye, that's so. 4 and 6pence are paid every week. Oh, that's a terrible lot of money for a working woman to pay.
I am sure that many agree with you. Now then, Miss Mackenzie, did you recently apply to the National Health Insurance for a hearing aid?
For what?
My lord, I must protest against the manner in which this question is being put.
I will repeat the question, my lord. I asked you in a normal tone of voice, audible to everyone in open court, did you apply to the National Health Insurance for a hearing aid?
Yes, I did.
Did you get it?
No, not yet.
However, you state that you walked past a door which is 4 inches of solid oak. You heard voices, and you are willing to swear that you could distinguish the voice of the prisoner, Leonard Vole.
Who?
No further questions.
That's a classic movie scene. It just demonstrates one aspect of hearing a witness testify in person versus reading a statement that the witness may have said that she heard something, but that there wasn't any examination of her ability to hear. So that's just a way to kick off our conversation. I'd like to ask each of our experts to just talk about their own opinions based on their own experience about the question of, is it worthwhile for you as a judge or a lawyer to actually hear the witnesses testify in person and to see them testify in court? And can you give us some actual examples from your experience for why that's valuable?
I have a couple of cases in mind, but generally speaking, of course, it's not only helpful, it's absolutely essential that witnesses testify. That it's just critical to see them, to hear them, and to have their testimony subject to cross-examination in determining their credibility. As I said, a couple cases come to mind. One was a rape case that I tried a number of years ago, where the defense was consent. There was DNA evidence in the case, and there was no question about there being sexual intercourse, and so the issue was going to be consent. And the complaining witness who testified shattered that defense, basically by her appearance, by the manner of her testimony, her demeanor, her reaction to being questioned. All of that was readily apparent from her being there in the courtroom, and would not have been if it had just been a question of putting in statements or previous testimony that she had given.
Marty, can I interrupt you just for 1 second? I just wanted
Sure.
to ask you something.
Sure.
Oftentimes when people think about witnesses testifying in court and some of the value of that, they think about cross-examination and the opportunity for cross-examination and to challenge a witness. But the example you're giving us, it sounds like the direct testimony of the witness was really what impressed you to begin with, and that
Absolutely.
You wouldn't have gotten that same impression had you just read her statement.
Absolutely. Demeanor, demeanor is a tricky thing. Witnesses can be nervous, and sometimes nervousness is looked at as some indication that a witness isn't telling the truth. But on the other hand, just appearing in court and in front of a jury is something that causes people to be nervous and hesitate in giving answers. So there is some real careful evaluation that needs to be done. But the reaction to being questioned is an important part of evaluation of credibility. The other example I had in mind was a suppression hearing I did in which ultimately a weapon was seized in a car, but it began with a car stop and a police officer indicating that after the car was stopped, that he smelled marijuana in the car. And under our law, the smell of marijuana is a justification for the search of the car. So the lawfulness of the search turned on the smelling of the marijuana, and the critical issue in the suppression hearing was whether that was believable. and having a report that simply said, I stopped the car for this reason, and when I asked him to roll down his window, I smelled marijuana, plausible on its face, but when this is being presented in court, live testimony, and there is a need to tell the story, then many more facts have to be presented, and the questions arise about how was the marijuana package, where was it in the car, was it in the closed container, was it in the glove compartment, all those sorts of issues that make the credibility of the story turn on facts that are more detailed than what you might find in a written report. And once again, that's a situation where both on direct examination and cross-examination, issues about plausibility, believability will emerge.
Okay, so two great examples. I think just to underscore the point, it sounds like just the ability to get more details from the witness to back up the conclusions that they state in their written report is one of the values you get from having the witness testify in court. Particularly where the report is authored by someone, let's say in this situation, it's authored by a police officer who is the percipient witness, the witness who saw or heard whatever it is that's relevant to the factual determination, where that person is in control of what gets said and what doesn't get said in the report, having only the report and not having direct and cross-examination really limits what the fact finder finds out.
I was actually going to begin my remarks by saying that I come to the question of the value of live testimony with some humility, because I work in a system that adjudicates matters only based on live testimony, so I don't have that much experience with a different kind of approach. But as I thought about it, I decided that that's not quite accurate. Many times judges are called to issue orders in connection with matters that are not genuinely in dispute, and we do so often based upon the submission of affidavits or other documents that lay out the factual predicate for the issuance of the order without the kind of probing we would engage in when a matter is contested. And sometimes I've dealt with the very same issue, both as an uncontested matter with a factual record presented to the court on paper, and in other cases, the same issue is presented in a disputed manner at a live hearing with witnesses. And the degree of probing and evidence that can be brought out and the insights that can be drawn from it are really quite different. And it makes me wonder how many orders I issued on consent of the parties based upon a paper factual record that wouldn't really withstand scrutiny if the matter was contested and presented in a live evidentiary format. I can think of two examples of cases where I did confront live testimony that I think would have looked very different had it been submitted on paper. In one case, I was prosecuting the owner of a business for a tax fraud. And the key witness against the owners of the business was the bookkeeper who created the books and records that formed the basis of the fraudulent tax returns. And this bookkeeper embezzled money from the business while he worked there. And this bookkeeper originally told the prosecutors, including me, a version of the facts that turned out not to be accurate, and he was prosecuted with more serious charges for having misled the government in his first version of events. And I'm pretty convinced that if that written record were presented to a finder of fact without meeting the witness and questioning the witness, it would be hard to find beyond a reasonable doubt that the owners of the business were responsible for the tax fraud, as this bookkeeper said, and not that it was the bookkeeper's own con. In fact, the bookkeeper admitted that he filed false tax returns for all of the businesses where he ever worked. But when you met the bookkeeper and you saw the remorse that he exhibited, he actually broke down in tears when he was telling an anecdote that was relevant to the case, and his father came up. He broke down in tears about how ashamed his father would have been if he knew what he had done. And there was another point where he was explaining what he had done with the money he embezzled, and he admitted that he had gone to a house of prostitution and spent most of it there. And the shame and humility and lack of initiative and leadership that he demonstrated during his testimony, I think made it clear to everyone in the room that he would not have devised this massive tax fraud scheme on his own and without the guidance of the owners of the business who were the defendants at the trial. I had an opposite experience in another case where there was a claim of sexual assault. And the victim of the sexual assault was a longtime employee of the organization where she claimed a coworker had assaulted her. She described the assault in explicit detail, actually remembering where in the building it had occurred and which hand was used and what part of her body was touched. And the level of the detail was really quite impressive, and there was no reason to believe that this witness would have made up this story of sexual assault. But there came a time when, after her direct examination, during which she was quite forthcoming and responsive, she was questioned by the lawyer for the alleged perpetrator. And at that point, she became very angry, very defensive, said she didn't understand the questions even when they were clear. And it became quite obvious to everyone in the room that she was exaggerating greatly or completely lying about what had occurred. And so by seeing these people in person, we gained sort of a three-dimensional sense of who they were and what their motivations were that a paper presentation could only have provided in 2 dimensions. I think it was very valuable to the accuracy, or very helpful to the accuracy of the results that were reached.
So thanks, Steve. I think it's a great couple of points, particularly when you have an important witness, either a cooperating witness in a criminal prosecution or the victim or the perpetrator. You really get a sense of the person when you see them testify, something that you can't possibly get an accurate picture of just from reading what they say. And one of your examples, even though there was tremendous detail in the written record, you still didn't get a sense of the person until you actually saw her testify.
That's right. That's right. And I think we all can extrapolate from our personal experiences with coworkers that, or family members, that sometimes it's not what they say, but it is the way that they behave when they say it, or when you follow up with a question, particularly in a work setting, you know, and some people are able to explain their responses and some people become defensive and you lose your confidence in what they have to offer you.
I fundamentally agree with everything that Judge Marcus and Judge Gold said. From my point of view, I can't think of anything more fundamental to the truth-seeking process than to have the witnesses present live in a courtroom, having to present their testimony and being subject to cross-examination. It seems very fundamental to me to the goal of determining the truth and making sure that the result of the proceeding is fair and just. In every case I've ever tried, there have always been significant issues for many witnesses as to whether their memories were accurate, as to whether they were telling the truth, which are two separate questions. And that those subjects of accuracy and honesty, in my view, can only be probed live. If you're looking at a piece of paper with a statement from the witness, I don't think you can effectively determine the witness's capacity and ability to be accurate, and also whether the witness is trying to be accurate or is the witness lying. So I would say it's fundamental why the live testimony is so much more important. First of all, when you're looking at a statement, I think you have to analyze, you have to know what is the process through which this statement was obtained. Whose words are there in that statement? Is this the product of the witness, or is it really the product of a lawyer or a prosecutor who's talking to the witness and putting it in perhaps the lawyer's own words? So you'd need to know the process by which a statement was taken to understand whether it has a truthful power or not. And for that, you'd need to understand it from the witness. Second reason that I think live witnesses are so important is human memory is just fallible. It is imperfect, despite our best intentions. People see things through their own perspective at the time that they're observing an event. And then as years go by, that perspective changes, that memory changes. And so even if someone's trying to tell the truth, there are always significant questions about their ability to really remember accurately what they're describing. And that needs to be probed in examination. And the third thing is that people do, sadly, intentionally lie. It is not uncommon. I've had many, many trials where I've come to the view that a witness was lying. Frequently, there's a reason for that, a purpose, a motivation, but it's critical to be able to probe those three areas: the process of any statement that was given, the ability of the witness to give accurate testimony, and the question of the witness is whether the witness is attempting to tell the truth or has some reason to be lying in the proceeding. So I can think of a couple of examples that illustrate these kinds of things. In the last trial I had, it was the defendant was actually a prosecutor, a lawyer and a prosecutor who had worked for many years on the prosecution side of cases, and he was indicted, he was charged with obstructing justice in another case. And the lead witness against him was a police officer who essentially testified that the defendant had tried to influence the police officer's testimony in another case to help the defendant in that other case, who happened to be the chief of police. So the defendant was charged with obstructing justice by asking another witness essentially to lie in an unrelated proceeding. So the star witness was this police officer who claimed that he had been asked to lie. And what we learned before the trial was that about 3 weeks before he started his cooperation with the government, he had been hospitalized, and he had had hallucinations, he had had delusions. He was in the hospital for 5 days, where he imagined that there were children in his room selling him ice cream who did not exist. And so this was a tremendous question of what was his mental state a couple of weeks later when he began cooperating with the government and giving them the information that was ultimately used at trial. And this was a very subtle and delicate point. The government's position, the prosecutor's position, was that although this had happened, it was a short-lived episode, and the witness had recovered from it quickly and could be relied upon 2 weeks after to be accurate and precise. The defense's position was no, this was essentially a witness who'd had a nervous breakdown of sorts, and their mental state could not be relied on to be giving accurate information 2-3 weeks after that episode. So given the subtlety, the nuance of that issue, it could only really be determined live. You have to hear the witness explain what happened. You have to hear the defense cross-examine the witness and try to prove that this is very, very, very relevant and that the jury should discount that witness's testimony. And you have to hear the government argue, no, this was a short-lived event. They should not discount his testimony. But I think there's no way without a live witness having to answer those questions that you could do that. One other example comes to mind. Several years ago, I tried a case involving one of the largest frauds in U.S. history committed by someone who's famous here named Bernard Madoff. And it was a multi-billion-dollar fraud involving the fake trading of stocks. And my client was a computer programmer who was charged with, he worked for Madoff, and he was charged with designing the computer programs that helped Madoff carry out the stock fraud schemes. And in that case, the government's star witness was Madoff's number two. He's the number two person in the organization. He was Madoff's chief assistant. And that person was testifying essentially to try to get a lesser sentence. He had made a deal with the government that he would plead to somewhat lesser charges and what would get credit for cooperating with the government in exchange for his testimony against a number of people, including my client who was on trial. So that's another instance where that witness took the stand, told his version of the facts, which were very detrimental, harmful to my client. But the question was a couple of things. Number one, was that witness lying because he was trying to save himself? That is a classic question that I think can only be answered live by the witness being questioned. The government argued, no, he's telling the truth. Yes, he's trying to help himself, but he still can tell the truth. The defense argued, no, he's trying to help himself, and so he's shading the testimony. He's exaggerating it. He's making up details so that he can get more credit for his cooperation. That type of debate, I think, can only be determined by the jurors or the judge by hearing the witness live and really seeing, getting a feel for, are they telling the truth? Are they exaggerating? Or basically, can they be relied on or not? That's something that can't be determined from a piece of paper. Has to be done live, in my view.
I wanted to add something. It's not quite the same situation, but I think it's important and in a way illustrates the same point. And that is, it's become common in New York now, and it wasn't in the past, for the interrogation of defendants to be recorded when the interrogation is being done just by police officers. It's been done for a very long time where it's a prosecutor asking the questions, but for the police, it's the last maybe 5 or 10 years. And the difference between having a written statement by the defendant come into evidence and watching an interrogation that's video recorded that goes on for 20 minutes or 2 hours or 3 hours is night and day. And the ability to see the questioning process is so critical to evaluating whether the statement is coerced in some way and whether the statement is truthful or not. It's really critical to see the video itself and not just the written statement or even just testimony from the officer who conducted the interrogation as to what ultimately the defendant said.
I get from what you're saying that when you, as the finder of fact, get to see the recording, it makes a huge difference in your understanding of whether you should rely on the statement.
It does, and over time, it has begun to produce and will continue to produce more sophisticated judicial evaluations of what's permissible and not permissible in terms of the techniques that are used in interrogating witnesses or defendants?
In my experience, one of the most important things that's probed at trial is the process by which, if there is a witness who's been interviewed many times by the prosecutor, perhaps he's made a cooperation agreement with the prosecution, or he's just been interviewed many times. It's crucial at times to probe that process to see the degree to which the prosecutors may have influenced the witness's testimony, maybe not unlawfully, but subtly, suggesting facts, maybe giving them a hint as to what they really wanted the answer to be. There are a number of things that are frankly difficult to probe from a defense point of view at trial, but are very important to probe. And if the prosecutor were to know that those conversations would never see the light of day because no one would ever get to ask questions about them, I think there would be much more of a problem with prosecutors unduly influencing the witnesses. Prosecutors are worried about not going over the line because they know that whatever they're saying to the witness can come out on cross-examination. It might not, but it can.
So the second question I wanted to ask all of you, if you are used to a system where witnesses don't usually come to court and testify, and you decide cases based on a written record, the evidence doesn't really change. And you're not called upon to make individualized determinations about whether a single witness is telling the truth or not. So the process of assessing a witness's credibility seems very difficult and almost, to those people who aren't used to it, maybe somewhat mysterious. So you've all had to assess the credibility of witnesses, whether as prosecutors or lawyers or judges. And I wonder if you could talk a little bit about how you go about that process. If from time to time you're called upon to articulate why you find a witness credible, why you find a witness to not be believable, I think that would be really helpful.
First of all, I do have to say that the process of determining credibility is very, very difficult. It is true. I don't think that's a reason to not engage in the process, because I think it's crucial. But it is hard, meaning at the end of the day, the person deciding on truth and not truth wasn't there when the facts described occurred. And so often one can never know for sure if a witness is credible, is telling the truth, is accurate or not. You are, at the end of the day, making an informed, educated judgment as to what you believe to be the case concerning the witness's accuracy and the witness's truthfulness. It almost can never reach the point of certainty whenever there are contested facts. It's a daunting process, but it seems essential to embark on the process in order to have fairness in a proceeding. So the way I think about credibility, there are a number of kind of classic, I call them earmarks of credibility or factors that are considered. I'll go through some of those. The first, one of the most fundamental questions is the issue of bias, meaning does the witness have some interest in the proceeding that affects what the witness is saying? Classic example would be the cooperating witness for the prosecution who's trying to get a lower sentence. That's a motive. The government would say it's still a motive to tell the truth, and the defense would say it's a motive to exaggerate to help the government. So it's subtle, but it's an important motive. And witnesses have all kinds of motives in cases. It may be that the defendant is an enemy of the family. They have ill will towards the defendant. Or on the flip side, the defendant is a good friend and they're trying to help the defendant. So there are many facets to the question of bias. What is the witness's interest in the proceedings? So bias is always important, but it's rarely dispositive, meaning a witness can still be telling the truth despite having a bias. So it's a factor that needs to be considered. I would say the next factor that needs to be considered is the capacity to perceive the events. So, for example, a witness testifies that he can identify the defendant as the bank robber, as an example. But it turns out that the witness was far across the room when the events occurred. There were many people in between the witness and the bank robber. And so there's just a basic question of how accurate is that identification? I will say that on the issue of identifications, there are just dozens and dozens of cases here, or really hundreds of cases, where there have been false identifications of a defendant. Identifying a person is actually quite hard. Unless it's someone that you've known for a long time, then it's easy. But if you are talking about a person that you're not previously familiar with, it is very hard to be accurate in your identification of that person. There are, particularly if there are cross-ethnic issues involved, it's been shown that it's harder for people to distinguish others of different ethnicities than from their own. So there are all kinds of questions of capacity to perceive and capacity to accurately recount that go into the question of determining credibility. And again, that's not a question of the witness deliberately lying. It's a question of whether the witness is unknowingly giving inaccurate information. The other classic things that we look at in determining credibility are whether the witness has been consistent in what he or she has said, or whether he or she has been inconsistent. In other words, you line up the prior statements that the witness has given on the same subject, and you compare that with the witness's testimony at trial. And of course, if they're consistent, it suggests accuracy and it suggests truthfulness. And if they're inconsistent, it suggests either mistake or intentional deception. Again, these are subtle points, and none really are dispositive unto themselves, but they're part of the factors that need to be considered. Another couple of factors are you want to look to some degree at the witness's prior character for truthfulness. In other words, there are some witnesses who come to court and we know for a fact that they've previously lied. They've been perhaps convicted of perjury in another case, or a judge has found that their testimony was not truthful in another case. Or perhaps they've just led a life where they've done fraudulent frauds that are proven. That's a person whose character for truthfulness is questionable. And you are allowed here on cross-examination to probe a witness's prior instances of untruthful conduct on the theory that if a witness has been untruthful in the past, there's a greater likelihood that they're being, or a greater risk that they're being untruthful in the proceeding at hand. And the last thing, which is the classic factor, is demeanor. How does the witness react on the stand? Does the witness seem evasive? Is the witness not evasive, but direct? That's again something that can only be evaluated in person. And again, it's very inexact. The person might appear to be evasive, and you could draw the conclusion that they're lying, but it might just be the witness is nervous and not doing a good job answering the questions. So these are very subtle questions, but at the end of the day, whoever's making the decision has to put all those factors together and try to come up with a determination of credibility. Sometimes it's easy, sometimes it's obvious, sometimes it's more difficult. I'll give one quick example from my Madoff trial, where the star witness, who I mentioned before, was Madoff's right-hand man. So that witness had led a life of fraud. He had been committing the Madoff fraud for 25 years, where he lied to all the customers. He lied to government regulators. He lied to everyone about that fraud for 25 years. So that is an example where that all came out at trial. When I cross-examined that witness, I went through in great detail all the prior frauds that he committed to show that he was a person of dishonest character. He lied so much he couldn't even tell the difference anymore between the truth and lies. So that was effective as to his credibility, and it's one of the things that goes into the test. What is the witness's prior conduct? Have they shown themselves to be a truthful person or an untruthful person? So those are the main factors that I would look at.
Although it's a difficult process, we have our next two experts are called upon from time to time to make those credibility determinations.
The list of factors that Larry just identified for everyone are very similar to those that we explain to jurors before we ask jurors to deliberate and decide upon the kinds of facts and make the factual determinations that trials raise. And they're also the factors that, as a judge, when we write opinions, we look to explain the reasons why we come out the way we do. I would amplify a couple of points that Larry made, and in connection, I think, with capacity, I would point out that something I'm always on the lookout for is a statement that is conclusory. That is to say, it makes an assertion without explaining how the witness knows the fact that the witness is recounting. Because sometimes when that is probed, what you find out is that the witness has drawn an inference from other facts and is now pronouncing a conclusion when you and I might not draw the same inference or wouldn't draw it as conclusively as the witness. And as I was listening to Larry, I was trying to think of a simple example. I hope since I haven't thought about it a lot, I hope it's not too simple. But imagine a witness saying, I saw the defendant rob the store. And then when you press the witness for what exactly did the witness see and observe, well, I heard the alarm in the store go off. I saw the defendant running out of the store very fast with merchandise under his arm that wasn't in a store bag or package. So I saw him steal the merchandise from the store. And then a video is found, and we learn that somebody came in with a gun while this man was online to pay with merchandise under his arm. And when the man came in with the gun and tried to hold up the cashier, the alarm went off and our defendant ran out of the store with the merchandise under his arm. And that's what led the witness to infer that the person was robbing the store, but in fact was not. So another example of where this comes up a lot is I deal with many search warrant applications where law enforcement officers prepare affidavits where they assert certain facts and contend that those facts give rise to probable cause to believe that a certain area will have evidence of crime in it, and I should authorize them to search that area. But if I am dissatisfied with the affidavit and I ask the law enforcement officer in paragraph 4, you say X, how do you know that? You haven't explained to me how you come to that conclusion. Sometimes I get a very satisfying answer and I ask for the affidavit to be amplified, but sometimes I don't, and I deny the application for a search warrant. Larry talked about demeanor and evasiveness. One of the things I look for, and I mentioned this earlier when I was speaking the first time, is how the witness reacts to the lawyer representing the side that the witness is connected to versus how the witness reacts when questioned by the adverse party, the other side in the case. So a witness who is calm and open and responsive to one side's questioning, but guarded and evasive and pretending to be confused and not understand the other side's questioning, has less credibility to me than a witness who is truly attempting to be responsive to both sides. Sometimes when I see a witness giving a lawyer what I think are evasive answers, I will interject my own question, not necessarily to learn the witness's answer to the question, but to see if the witness's attitude and demeanor will change. And if there is a marked change when I ask the question, then I get the sense that the witness is tailoring their answers depending upon who's asking the question, and I lose some confidence in the credibility of the witness. The other thing we always look for, of course, is corroboration. And by that I mean, is there other evidence in the case that ties in neatly with what the witness is saying or not? And particularly in these modern high-tech days where cell phones tell us where people go and text messages and emails and Facebook posts tell us what people are thinking at the moment of an event, there's often corroboration or contradiction in the objective electronic evidence that can help us determine whether a witness is being accurate and honest or inaccurate and evasive. And so those, I think, are the points I would make in amplification of what Larry's already discussed.
I want to just note a couple of things. Larry mentioned how difficult it is sometimes to make credibility determinations and how important it is to actually have the opportunity to see the witness. And Steve mentioned to see how the witness responds to questioning from their own lawyer, from the lawyer from the other side. I just want to mention a few things for our colleagues who are practice in other jurisdictions. There are certain features of our system that take into account the value of seeing witnesses testify in person. One is our standard of proof is proof beyond a reasonable doubt. So in a lot of the examples you mentioned, you may have come to the conclusion that the witness was not telling the truth, or you may have come to the conclusion that there's just too much doubt about whether the witness is telling the truth, and the standard of proof would take that into account. The second point is, if you make a credibility determination as a judge and you've heard the witness, in most cases, an appellate court, anyone who reviews your work doesn't really have the authority to change that determination because they haven't seen the witness. They haven't had the experience that you've had. And of course, you all mentioned jury trials, so that we give this decision-making power of assessing credibility in many, many criminal cases to ordinary people with the kind of instructions that you've talked about. And so with some of those additional points, I want to turn to you, Marty, and you've had a lot of experience and you've often been called upon to make decisions about whether or not you believe a witness or whether a witness is believable. And can you share with us how you go about making those decisions?
Whatever the jurisdiction is, there's a burden of proof everywhere, however it's described. And if there is a real issue about credibility, that's one way in which it can be resolved. The other point I wanted to make, and you began to make this point as well, is that customarily in our system, it's jurors and not judges who are making these decisions. And when I go through the jury selection process, particularly if it's a murder case, any kind of very serious case, I'm going to get one or more jurors who are going to say, you know, I really don't feel comfortable doing this. I don't think I'm equipped to do this. This is too serious for me. And what I tell them is that, you know, there's no special skill involved in determining the credibility of a witness. We do this all the time in our ordinary lives, in big decisions and little ones. People tell us things, and we have to decide whether they're accurate and whether they're truthful, whether it's buying a car or investing in a stock or getting married or much more trivial kinds of decision making. And all the factors that have been mentioned are the factors that I take into account in evaluating credibility, but every one of them requires the application of common sense, and it's a common sense that jurors have and judges have and need to be employed in making these decisions. When there is an inconsistent statement, for example, the question is this an inconsistency about something that is important, or is it about something that's not important? Is it the kind of detail that would be memorable or not? If something is left out in a prior statement that is mentioned in the testimony on trial, is that something that the witness likely would have mentioned in the previous statement? Was the witness's attention directed to it? You know, what's the significance of that particular fact being left out? Obviously, witnesses are prepared all the time to testify. They will go through, whether it's prosecution or defense, the questions they're going to be asked and the questions that they might be asked. They're shown prior statements that the witness has made. And again, the question is, common sense, was this preparation just reasonable given the fact that time has passed since the events in question and the witness's recollection needs to be refreshed? Or is this an attempt to coach the witness into saying things that are not truthful? When a witness is nervous on the stand, is that nervousness because the witness is lying, or is it nervousness because of the situation that the witness finds himself or herself in the courtroom? When a witness is reacting, for example, when being asked questions by the defense differently than when being asked questions by the prosecution, is that evidence of evasiveness, or is that someone who is just indignant at going through the process and angered by the tone or suggestion of the questions on cross-examination? These are all matters of common sense that need to be considered in a common sense fashion. It's one of the odd things about our system that when a defendant waives a jury, and I'm the finder of fact in the case, and I make the determination of guilty or not guilty. In that situation, I'm not obliged to make findings of fact. It's enough to just say guilty or not guilty. And in fact, most judges, at least in New York, when they find themselves in that situation, will do little more than saying guilty or not guilty. On the other hand, when we do decisions in suppression motions and other kinds of motions where there are hearings, in that situation, we do need to make findings of fact and reach conclusions of law. And in that situation, it is important to go through, if you're going to disbelieve a witness, or believe the witness, the factors that lead you to that conclusion, particularly where there is a challenge to credibility in the arguments that are made after the hearing is concluded. And then you go through these factors, maybe not all of them in every case, but the ones that are of particular importance in the context of that witness's testimony. and explain in some detail why you reached the conclusion that you did. It's another oddity of the New York system, by the way, that on appeal in the intermediate appellate court, the appellate division, while the appellate judges haven't seen the witnesses, they are in a position under the law to make a determination that I'm not, that the evidence is that the verdict in the case, a guilty verdict, was against the weight of the evidence. That is, in a more general kind of way, that they find that a reasonable person would not have found the evidence sufficient to find guilt beyond a reasonable doubt, and they can then reverse the verdict. My review is limited to whether the evidence is legally sufficient, and I would have to find evidence to be unbelievable as a matter of law, which is a really tough standard to meet, in order to throw out a jury's verdict. I go back to what I said before about using common sense. Some inconsistencies. Let's talk first about inconsistencies in various statements the witnesses made, the testimony at trial, in prior statements. And sometimes an inconsistency is a kind of glaring inconsistency. It's not one that you would explain by the passage of time. It's not one it's not the kind of change of testimony you would expect just because if you tell a joke 3 times, you're going to tell it 3 different ways, and the same thing in telling a story. But some inconsistencies are of such significance that it does question whether the statement that's being told in court is true. When it comes to inconsistent statements among witnesses, once again, you're going to be evaluating credibility of each one of the witnesses and determining whether they're both telling the truth, whether there's a reason based on all the factors that we've talked about to believe one witness over the other. But sometimes, for example, if it's an identification case, the issue is this the person who committed the crime, say a robbery or whatever. If it's a one witness identification and the victim of the robbery says that's the person who did it, and there are one or more witnesses who are alibi witnesses who say the defendant was somewhere else at the time, and their testimony is sufficiently plausible that it creates a reasonable doubt, then that's a reason to find the defendant not guilty. So the answer, I think, in both of these situations is apply common sense and keep in mind the burden of proof.
So if I could add something there, there are 2 different ways that inconsistency becomes important. One is when something is actually different from a previous statement. The person said before the light was red when I came to the corner, and then comes to trial and says the light was green when I came to the corner. Those are 2 just irreconcilable differences. And usually when there's a direct contradiction, the factor that has to be considered is how important is that contradiction. If it's a minor fact, you might think, well, they got one minor fact confused. They're still basically telling the truth. But if it's a major fact, if that was the center piece of the case, if that was the heart of the case, was whether the light was green or red, and they got it differently 2 times, there you'd have to conclude we can't rely on this person's view because they got such an important fact wrong, or at least inconsistent. The second type of inconsistency, which is more complicated to deal with but comes up all the time, is when it's not actually inconsistent, but there is an omission from an earlier statement where something is left out of an earlier statement that logically you think would have been included if it was true. So for example, a witness describes some kind of crime, gives a statement, then comes to court and adds an important fact that wasn't in the prior statement. It's not inconsistent with it, it's an additional fact, but an important one. And then you come to the question, why was that fact omitted, not included in the prior statement? Are they making it up later to fill in the story? So, quick example, in my prosecutor case that I mentioned, the star witness who testified for the prosecution gave a very incriminating version of the facts against my client. When he came to trial, he added an incident that had never been in his 4 years of statements. There had never been this statement before. It was an additional allegation against my client that he had attended an extra meeting where incriminating conversations supposedly took place. And that meeting had never been discussed in the prior statements. So it didn't contradict the prior statements, but it was absent from the prior statements. And this led to a debate that we played out, and my position was, you can't rely on this additional meeting, because if it were true, it would have been included right away, because it was too important to omit initially. So he must be making it up now. The government said no, it's just something he remembered later on. He's not lying, it's true, it's something he remembered later. So this debate about inconsistencies applies to both direct inconsistencies and inconsistencies by omission. And again, there's no magic answer to either of them. You have to weigh the importance and use your common sense to judge credibility.
I mean, one of the things you might look at, correct me if I'm wrong, Steve, is, was that written statement prepared by a police officer? Was it prepared by the witness themselves? Was it testimony in another proceeding? Or was it a summary? And you know, I would ask Steve, when you've come across this in your experience, how helpful is it to have the witness there to possibly explain, you know, why the statements appear to be inconsistent?
Well, it can be very helpful, as your question suggests. And in fact, very often you'll see attorneys suggest that there's an inconsistency between two statements or an omission from a prior statement that fails to include a fact that is now being testified to at trial. And sometimes there's a very powerful explanation for why. For example, during the prior interview, the questioner never brought a particular meeting up or brought a subject up because the investigative team hadn't learned about it yet. So having the person there to be confronted with the inconsistency and explain it can go a long way towards helping us evaluate whether the inconsistency is a strong indicator of credibility or not. One of the things I was going to also say is that sometimes we can look at whether there is a motive for the inconsistency. So for example, if we know that the location and date of a meeting is important to the question raised at trial, and our witness tells us one thing on day one, and on day 2 or 3, the witness learns that his cell phone records have been subpoenaed and are going to be reviewed by the government or the investigators or the court before a decision is made. And the witness then says, oh, you know, I made a mistake about where and when the meeting took place. That's an inconsistency that makes me very skeptical, because it seems to be triggered by the notion that the earlier version can be tested against some objective evidence. And so that's just an example of how a motive for the inconsistency or the lack of one can help us decide whether it's reflecting lack of credibility or whether it's an innocent, different recollection on different occasions, just as who authored the statement can often inform the significance of the inconsistency.
About inconsistencies, it's the nature of things in the Bronx where I preside that the vast bulk of the cases I try involve street crime, and identification testimony is very important in those cases. And one of the issues that often comes up is the description that the victim or a witness gave of the appearance of the perpetrator, of the person who committed the crime, becomes critical in determining the accuracy of the identification. And again, this is a situation in which common sense comes into play. What is it that was wrong about the description? If the person says it appeared to be somebody in his 30s and it was somebody in his 60s, that's important. If it's somebody 30s and the statement was that it was somebody who was 28, that's not so important. Facial hair might be important, a tattoo might be important, all of those things. So you have to look and see in this, I keep using the word common sense, but it's very, very important. Is this the kind of mistake that anybody could make? Or is this some indication that it's the wrong person?
When I write an opinion in a case where I'm the finder of fact, I will often say that although Mr. Belkin testified to fact X, I choose not to rely upon that testimony because when he was interviewed before the trial, he denied that fact X was true, or it is clear that it is in his interest to claim that fact X is true, and he had a motive to say that at the trial. But when we look at his records and documents, there's no reference to fact X, and we would have expected to find it there. So I'll say things just like that, in my opinion, to explain why I'm reaching one conclusion of fact rather than another.
Whether the evidence is overwhelming or not is a difficult determination to make in the absence of live witnesses. And you might reach a conclusion simply looking at the dossier that the case is overwhelming, but if the evidence is then tested in the courtroom, it turns out not to be so. There could be issues about the DNA testing or how the DNA sample was acquired, whether the confession was coerced, all kinds of things that won't be readily apparent from just looking at the trial. And if the defendant wants to raise those issues in a courtroom, that ought to happen. I'm just worried about reaching a conclusion that the evidence is overwhelming in the absence of actually presenting the evidence.
I don't want to belabor that point, but I will add that there are times when you look at the pretrial materials and you reach an instinctive, intuitive judgment about how the trial will come out. And then you take the bench and you hear how things unfold and the points that the lawyers raise, and you look at the witnesses testify, and you change your mind and you see things from a different perspective. So I think that there's a certain, I hate to use the word, but it's the only one that's coming to my mind right now. There's a certain arrogance about thinking that as judges, we can figure out whether there is an important dispute of fact or not, and we should decide that this case doesn't need to be tried and the lawyer's just wasting my time by asking for a trial, because I find that when I'm in the courtroom and I listen to the trial, I'll always learn something new. It may not be enough to change my mind, but sometimes it will be.
So I'll add my perspective as a criminal defense lawyer. Where the defendant is not admitting the facts and is asking for a trial, I think the problem is who gets to decide that, oh, in this case, the evidence is so overwhelming that you don't get a trial. But in another case, well, the evidence is not so overwhelming, so you do get a trial. Because the problem is, in order to make that determination, you almost need a trial to decide if the evidence really is overwhelming or not. If you're just looking at, for example, a confession, which is probably the most devastating evidence that there is against a defendant, is a confession to the crime. But truth be told, confessions are not always reliable. There are many, many cases in the United States where it turns out that the confession was unreliable in some way. Maybe it was coerced by the police. Maybe it was done in some psychological coercion, if not a physical coercion rather, which lead to reliability questions about that confession. So if you were to just look at a confession and say you don't get a trial, that defendant would never have the opportunity to try to show that there actually is an explanation for that confession and it is not reliable. It actually was a false confession. Now, that's the minority of cases, but they exist. There are actually quite a few. And so to me, you would need, as a defense lawyer, you would need the opportunity to present that as a possibility. And without a trial, I don't see how you do that. So I think the question is, there's no way for the judges to be the gatekeeper of whether someone gets a trial, because they need to know what's underneath these pieces of paper that they're looking at before they can really make an informed view of whether the evidence is really overwhelming or not. So I think a trial is the best way to do it with live witnesses.
I would just add that there are situations in which there might be overwhelming evidence that the defendant is guilty, but the question is guilty of what? And just an obvious example is in a homicide case where there's no question that the defendant caused the death of the person. There might be an issue as whether he caused it with the intent to cause death and be guilty of murder, or whether he did it with the intent to cause serious physical injury and guilty of only manslaughter, and down the road. So there are subtleties to this that would make a trial necessary, even in a situation where the defendant's involvement in the crime is clear.
So I wanted to make another, or ask a related question. In addition to making the trial the center of a criminal case, that the people should feel fairness and justice in every case. You've described situations where once you've heard the evidence at trial, you've learned something new or it's changed your mind. And I want to ask if you've had questions or experiences where during the trial, questions were raised, but by the end of the trial, your questions and your doubts were satisfied, and that even though you didn't change your mind, the process gave you more confidence in the outcome. And whether there's just a value in having confidence in the outcome, that the defense had every chance, every opportunity to challenge the evidence. They made some points, but at the end of the day, you found the evidence was sufficient. And having given the defense the opportunity to raise every challenge they could, that you felt the jury's verdict, you just felt it more confident.
I take as a very important part of my job, and I think most of my colleagues do as well, enhancing or working toward having the public and the community have confidence in the transparency of what we do and the integrity of what we do. And that's why our courtrooms are open. That's why I think good judges try not to cut lawyers off until they've had a chance to make their point, and why we let both sides have the right to be heard. It's also why we have a confrontation clause in our Constitution that says that every person who is accused of committing a crime has the right to confront the witnesses against them. And I have an example that sticks in my mind, even though I was a brand new judge more than 25 years ago when it happened. And it was a civil case, not a criminal case, but a plaintiff who was seriously injured using a product sued the manufacturer of the product for the damages he sustained from using it. And the trial made pretty clear that he used the product unsafely, and it wasn't the manufacturer's fault that he had such a serious injury. He lost an eye. It was not a minor case. And his wife sat with him during the trial and afterwards wrote me a letter and said, I know my husband lost his case, but having had an opportunity to sit in a courtroom where all of the evidence was put forth and examined and scrutinized by the lawyers for both sides, and knowing that the public or the press could have walked into the courtroom at any time, made me feel like he had a fair day in court and that he had his opportunity to tell his story and to have it tested. And I think that as important as that was to that man, it's even more important when someone is accused of committing a crime, that those who are accusing them be tested and probed, and that the community and the family of the person accused and the accused himself or herself knows that before they're being sentenced to custody, knows that before they're receiving the critical eye of society and their government, that the case against them was tested in an open adversarial way that gives us confidence that the possibility that the paper record doesn't tell the whole story has been explored. And so that's what I would say on that subject.
I think it's important to point out, and it's easy to overgeneralize this, but if a witness essentially says the defendant did it before trial and is going to say at trial the defendant didn't do it, or actually says that at trial, for the most part, the prior statement that the defendant did it is not admissible at the trial. It's not what he said before, it's what he's saying now. There's a limited situation in which, in New York, that witness could be impeached with the prior statement, but it's very limited, and it only is impeachment. It's not direct evidence. There are situations, though, where a witness is recanting, refusing to testify, whatever, where a prosecutor can present evidence in a hearing that takes place outside of the presence of the jury, in which the prosecutor attempts to prove that the defendant directly or indirectly is responsible for the recantation. And if that happens, then that statement, the prior statement, can come into evidence and be used at the trial. So I would just add that on that question.
With respect to the recantation, talk about a reason to have live testimony and not rely on the paper record. If we were relying on the paper record, we would have the accusation untested and not treated in the same, and not put through the rigors of a trial And we would end up convicting the people of gambling even when that witness now is saying that it didn't happen. I think it enhances the argument or enhances the position that live testimony is of critical value. I'd also revert back to Judge Marcus's comments about burden of proof. That's why we have the proof beyond a reasonable doubt standard when the evidence leaves us uncertain, because we don't know which of many inconsistent versions to believe, then we don't act. And it's where the expression that it's better the innocent, it's better the guilty go free than the innocent are punished comes from. For many witnesses, the mere fact of coming to court, testifying under oath, in front of a judge, in front of the public, and subjecting him or herself to cross-examination is in and of itself a strong indicator of the credibility of the witness. And when the witness won't come forward under those circumstances, it might be a sexual assault victim who is too burdened with shame or embarrassment about what happened, but it might also be an indication that the evidence is unworthy of belief because the witness will not stand behind it.
On the issue of special witnesses, whether it's a sexual assault case, whether it has to do with voluntariness, I would add to that the special problems that arise in identification testimony. There are situations in which an expert witness might testify to help the jury in understanding things that are, the phrase we use is beyond the jury's ken, beyond the jury's understanding in evaluating that kind of testimony and what might explain why things appear to be different than they do. Explain the otherwise inexplicable. So for example, in identification testimony, their expert witnesses have testified about difficulties in cross-racial identification problems. Witnesses of one race have identifying somebody of another race. We've now begun to hear expert testimony about defendants making false inculpatory statements, falsely saying they committed a crime that they didn't commit. More controversial in sexual assault cases, there's expert testimony that's sometimes offered to explain why it is that witnesses don't report a sexual assault right away or otherwise behave in ways that seem inconsistent with sort of a layperson's understanding of how you would react. So those options are available, at least to a limited extent, to explain those cases.
It is true that here, after a defendant is convicted either by a trial or by having pleaded guilty, there is a sentencing phase that's governed by a whole different set of rules than the rules governing a trial. At a trial, the proof of guilt has to be beyond a reasonable doubt. But at sentencing, once the defendant has been found guilty of the crime, additional factors that might influence the sentence only have to be found by the judge, not the jury, by a preponderance of the evidence, which is a lower legal standard. But I would say the issues of credibility and assessing credibility aren't really any different. It's just a lower burden of proof. And it is not uncommon here. You are allowed as a defendant to have yet another hearing at the time of sentencing if you challenge a particular new fact that wasn't determined at the trial that the government wants the judge to consider. You can ask for a hearing where live witnesses are called again on that additional fact. And the judge then has to make a credibility determination, although it's done by a lower standard of proof of preponderance of the evidence.